Welcome. Thank you ever so much for joining us this morning for this session where we're going to be looking into a number of employment law myths and misunderstandings. Quick introduction, my name is Katie Burley. I'm one of the senior associates in the employment team here at FSP, and I'm going to be hosting the bulk of this session today. I'm not going to prolong the start too much because obviously we've got lots to go through as we normally do. There's just a couple of little things that I'm going to flag just before we start. As you're probably very much aware, this is obviously a remote session. If we do have any technical difficulties, we'll aim to resolve those as quickly as we possibly can, so please do just bear with us. We'll hopefully have you back on track as soon as we possibly can. Timings, we have about an hour for this session today. That's including the questions at the end. You are on mute, so everybody at home is all going to be on mute, but if you do have any questions, there is a little question box that you can put questions into, and we will endeavour to answer as many of them at the end of the webinar as we possibly can. I do have two of my esteemed colleagues who I've roped in to join me at the end of this to help with those questions, so we will be joined by Ian Machray, a partner in the team, and Jackie Denham, also a senior associate, to help with any questions that you may have. If you'd like to post those as you go along, we will try and help with those at the end. There are going to be some polls throughout the webinar. Please do get involved with those. We'd like to hear any sort of thoughts that we have as we go along, so look out for those. This is being recorded. The recording is normally sent out the same day. If we have any problems, it'll be sent out to you tomorrow, so watch your inbox for that, and you can watch it all again if you've missed anything. And just a quick point that at the very end of the webinar, we would love to get some feedback from you about what you thought. There is an incentive, the usual incentive of £50 John Lewis voucher for those who complete the survey, and you will be entered into a prize draw, and one lucky winner will win that. So do hang on to the very end, and that should pop up on your screen. Right, before I get started, just for the purposes of today, I'm going to necessarily need to assume that you all, or everyone who is watching today, has sort of a basic level of understanding of some key points of employment law. Now, for those of you who regularly attend our webinars, you will normally that we pick a particular topic and we drill down quite deeply into that and look at all the different laws. For today, given the wide scope of what we're trying to be covering, you will hopefully appreciate there's not quite time to do that for every different type of scenario that we're going to give you. So the answers that I'm going to be giving today aren't necessarily intended to provide the complete solutions to every scenario. There will obviously be different things that could happen, different facts depending on the cases. So just giving the benefit of the doubt on that, if that's okay, I will do my best. So to start us off, I'm going to start us off with the first of our interactive polls, which should hopefully pop up on your screen shortly, and that will get us started. So bear with me, there it is. So the poll is, does it matter if an employee does not sign their contract of employment? And I've given you a couple of different scenarios there of things that you can answer. So yes, no, or you're not actually sure. So, you know, we all know this situation. You issue a load of new contracts to staff, you ask them to sign them and return them. Sometimes you even give them a lovely little bit that they can sign. They don't have to do anything. Just sign it, send it back. And there's a handful of them that never come back. Now, does this matter? And I'll give you a little time to put your answer in there. That won't take too long. It's a fairly simple question, this one. So, no, does not matter. And actually, this is a very, very common answer. There's quite a few of you saying it does as well. So it's a mixed bag there. So if I'm moving on to the next slide then, the question that I'm posing, so the first potential question I'm posing is, it doesn't matter if an employee doesn't sign their contract of employment. Just wait, the slides are going to catch up with us in just a second. So that's the question. Now, interestingly, this is actually a myth. It does matter. And the common perception here often comes from the fact that unless the employee has expressly objected to any of the terms, if their employment's continuing, most of the terms of the contract are likely to be deemed accepted by the pure fact that the employee is continuing to work without that clear objection being in place. Now, you're paying their salary, they're working their hours, the terms are largely being applied and abided by both parties. But this is where the problem comes in. Any issues which are sort of like untested clauses, you know, things that aren't being applied day to day, things that aren't part of your normal relationship with somebody, and that you might later want to rely on, most commonly when the relationship comes to an end for one reason or another, and those termination provisions then need to be implemented. So they are untested, they haven't been tried until that point. The most obvious example is things like restrictive covenants, which obviously they tend to come into place at the end of the employment relationship, and that's the point when you're going to first want to try and enforce them. Similarly, however, there are things like breach confidentiality provisions, intellectual property provisions. I mean, even more so where your intellectual property provisions have a power of attorney included in them. And that actually requires the contract to be signed as a deed. Again, if you don't have that signature, it's not going to work. So those types of clauses, these untested clauses, may not automatically be deemed valid in the absence of a signature. So obviously, if you get to that stage, you've checked, you haven't got that signature, and you want to be able to enforce it, it could just give you more of a headache than you had anticipated. It doesn't mean it definitely won't be valid. Doesn't mean it's an absolute, sort of coach through horses situation. It's not that, but it could give you more of a headache than you anticipate. So certainly, if you don't get that signature, and if you don't have that coming back to you, we really recommend that you do try and get it if at all possible. Okay. My next one, so moving on to the next slide, my next scenario or statement I've got is having a self-employed contract in place will negate any risk of the individual being deemed a worker or an employee. So if you've got a lovely contract in place, that's it, it's in writing, this person is going to be self-employed. Now, this is another myth. The existence of a self-employed contract will not in itself determine whether an individual is considered to be self-employed or a worker or employee in the eyes of either the courts and or HMRC. So when it comes to employment status, the process that the tribunal and probably HMRC, depending on who's actually looking at it, will undertake really is looking to examine the reality of the relationship that's in place. And that's when we see all of those normal employee tests that I'm sure most of you know, the Remedy Concrete case, which sets out things such as, is there personal service, what level of control is over the individual, what's the mutuality of obligation, all of those sorts of things are looked at, and it's that's looked at. Don't get me wrong, the contract is incredibly important. We'd always strongly recommend that you have one and that it sets out the basis for your relationship. But at the end of the day, you can have an absolutely wonderful, perfect contract that sets out completely the correct stance on it, but it actually needs to be true. It needs to reflect the relationship that you've actually got in place with that individual. When we're drafting these, we will of course look to make sure that those key tests are within the document and that they are reflecting actually what it is that you're doing as far as possible. But if you then go away and you don't actually apply any of those and you do something very different, that's not going to guarantee you that you've actually got the status correct. Now, I was going to briefly mention things like IR35 legislation, HMRC CES tool, that sort of stuff today. However, given the recent news that obviously the current position is that IR35 is set to be repealed from next April, I'm actually just going to move straight on because I'm not going to go over something that is likely to not be with us that much longer. I'm sure that is something that Ian Machray is going to cover in his seminar in January when he's looking at obviously what's coming for the next year. So watch this space on that front. Okay, next slide then. So we're still looking at contracts, and this is quite an interesting one, I think. So the statement I've written here is if an ex-employee breaches their settlement agreement, we will always be able to get our money back. So, someone's breached the obligation that they're not meant to bring a claim, or they've breached a confidentiality provision or something in their settlement agreement. It's like, well, do you know what? Fine, we'll get our money back that we paid them. Now, this isn't technically a myth, but I'd say it's perhaps more of a misunderstanding. That's the way I would look at it. Now, I'm not going to tell you that you're not going to get your money back if you have somebody who breaches a settlement agreement, because, well, hopefully you would, and you certainly might. However, the reality of the situation is that it actually doesn't always come easy. It's not as simple as just running off to court and automatically getting your money back. While you may have a wonderful document in place that's been very carefully drafted, you've got all sorts of appropriate terms to require repayment in certain circumstances, the reality of the situation can quite often be, and certainly is, that litigation for breach of contract can be incredibly expensive. You can very easily spend more on actually pursuing the individual for the breach than the sum that you're actually trying to recover. Now, obviously, there's the bigger moral point here of saying, well, actually, if they've breached it, well, we want to try, even if we have to spend double the amount by going through the courts, we'd rather get our money back because it's a principal point and they've done the wrong thing. However, that for many businesses is actually going to be prohibitive to pursuing that sort of claim. I mean, there is an argument to say that legal fees are usually paid by the losing party, at least in part in the civil courts, but the level of these aren't guaranteed, and you're obviously not going to get the management time back that you spent on the claim and all of those sorts of things. So it's a big consideration if you actually want to go after somebody for breach of contract. Now, the other important thing to think about in this circumstance is actually the individual's ability to be able to repay the money that you're trying to pursue them for. You know, if they've already gone out, they've already spent all of that money, and they've got no other adequate means to repay the sums, again, you might end up not actually getting your money back. So you might get a wonderful court judgment that it goes in your favour, but no ability to actually recoup those funds. So quite often, while the reality is that you've got a very good settlement agreement, which again, they're really important documents, we very strongly recommend that in the right circumstances you put one of those in place. Actually, if you do end up with a breach, it's not as straightforward as saying, well, it's fine, we're just going to get our money back. Okay. Right. The next slide then, continuing with contracts of employment, and this is having a lovely look at TUPE. So the statement that on this slide is, you can harmonise contracts of employment after a TUPE transfer as long as a reasonable period of time has passed. And this one we do see, again, quite commonly. Now, this is, again, a myth. As I said at the beginning, I'm working on the basis that hopefully most of you who are attending today will have heard of the Transfer of Undertaking Protection of Employees Regulations, more commonly known as TUPE. So I'm not going to go into the background of actually what this means, but obviously if you are inheriting a load of employees, perhaps on the purchase of a business, something along those lines, the result of TUPE means that they will retain their old contractual terms and conditions in the vast majority of circumstances. You can look to agree whatever you want. You can try and put new contracts in place, you can try and do all sorts of things to change it, but the fundamental principle of TUPE is that if the change relates to or is by reason of the transfer, that it really won't matter, it will be automatically void, which you can imagine give quite a lot of headaches. So, as I say, any attempts to vary those new contracts by the new employer will be void, and particularly includes those changes that are trying to be made as part of a harmonisation process for the contracts of employees. So, as you can imagine, if you've got a whole load of new employees joining your business, you've also got a load of existing ones, you've got two sets of people on very different terms. The desirable situation would be to have everybody under the same terms, same benefits, same principles, same hours, all the sorts of stuff, like nice things like that. But TUPE just doesn't let that happen. And what we often get asked is, well, you know, come on, it's been a few months now, or it's been a couple of years, surely this doesn't actually matter. Does it really actually relate to the transfer? The reality is that actually TUPE can be run indefinitely. This provision about this change can quite happily run indefinitely. It doesn't really matter how much time has passed. If the changes are made, if they still relate in some reason to the transfer, which is pretty much always going to be the case for harmonisation of terms, they're likely to be void. There are a couple of exceptions. And so I'm not going to go into great detail today, but if there is an economic, technical, or organisational reason that involves a change to the workforce, can come about, for example, for restructuring, redundancies, you know, change to actual necessary changes to the place of work or changes to sort of new processes or equipment, those sorts of things can be valid. There is also an argument to say that actually you can make enhancements to the benefit of the employee, and the employee will happily take those. But the reality is there is a chance actually those could be void as well. It's just that the employee won't challenge them. Why would they? You're going to give them more money, new benefits, those sorts of things. They'll probably quite happily take them. The risk, of course, is that anything that is negative, for example, restricted covenants, those sorts of things, those particular points would be void. The other slight exclusion, which I won't go into as well, is pensions. So obviously pensions, if you can't keep the same pension provider, if it's a company-owned matter, then you would need to change that over. But again, that's an exception as long as you're providing very similar terms. In practice, many businesses do elect to take a risk on this, and they take a bit of a view on the thing, and they think, look, do you know what? Let's introduce the changes. Let's just hope for the best. There are all sorts of ways that you can actually encourage your inherited employees to accept changes to their terms and sign up to new contracts. You know, if you want to get those restricted covenants in place, you might add a nice new bonus scheme at the same time as a contract as an incentive to actually get them to physically sign on the line. This kind of practice does have to come with a massive health warning, however, that while you might get those contracts signed and the relationship may continue quite happily, no other challenges ever raised, you have to walk into it with very open eyes that actually this might not work. You know, if the employee happens to be wise to the principles of TUPE, which granted, not many are, but if they are, they could happily take those improvements, work with them, and then actually when it comes to leave, and they don't want their restrictions in place, well, I'll say actually those related to the transfer, that's why you put them in place and they're not valid. And that could be entirely correct. The point about TUPE, it is an automatic principle. It's not something that people can just contract out of. It is a point of law and it will apply, despite any deemed agreement to the contrary. So it is something to really be aware of. Now, there are various tricks in the trade that can help you sort of come as close as you possibly can to having enforceable new terms. But I don't have time for that, unfortunately, today. Hopefully, we'll be doing a full TUPE workshop over the coming months, maybe the early part of next year, which you can sign up to if you are likely or if you have a particular interest in coming up to speed with TUPE. Right, moving on then into the wonderful world of dismissals. And so I've got a few particular scenarios that are going to come onto dismissals. First one, you can't make an individual who is on maternity leave redundant. This is a myth. You can indeed make an employee who is on maternity leave, or indeed an employee who is pregnant, redundant. It is a very common piece that people think this is absolutely not okay, but it's something that you can do. However, there are certain things that you need to make sure are correct if you are going to do that. Now, Regulation 10 of the Maternity and Parental Leave Regulations 1999, which you've got up on your screen there, says that an employee on maternity leave has the right to be offered a suitable alternative vacancy, meaning that if a vacancy fits that criteria, and granted, the definition of suitable alternative vacancy is quite particular, so you'd need to look at it quite carefully if that sort of thing is likely to apply, but it could. And if it does apply, that employee will actually need to be given priority over other employees in being given that role. That's the principle, and that's why people struggle, because it is because of this piece that there are alternative roles and who actually is going to be entitled to those. Just as a side point on this, it is actually important that if a redundancy situation arises during somebody's maternity leave, that you actually deal with that as and when it arises. So you shouldn't wait until the employee comes back to work after they've completed their maternity leave. They should be consulted as part of that, whether it's on maternity leave or not. And obviously, if there is a role that comes available during that time that she's on maternity leave, then she should be offered it as soon as as soon as her role actually is at risk. So that can happen, as I say, despite the fact that she is still on leave at the time. So what you would do in that scenario, you would obviously make the offer to her, assuming that she accepts, and she would continue on her maternity leave until the normal time when she would return, and then she would start that new job. So you would have to hold that job open for her. As I say, there's always different ins and outs of this sort of scenario. I'm not going to go into the full details, but that is the general principle. If you don't do that, you could well have a claim under Regulation 10 for automatic unfair dismissal, and in some cases, obviously, it would also be maternity discrimination as well. So one to be aware of. Next one. So when an employee is dismissed for gross misconduct, you have to pay them for accrued but untaken holiday. This one's actually true. I thought I'd mix it up, have something that's actually true in there. So yes, you do indeed need to pay any accrued but untaken holiday in a circumstance where somebody's dismissed, whether it is for gross misconduct or otherwise. You don't, in a gross misconduct scenario, have to pay them for any notice period, but things like holiday, genuinely accrued business expenses, salary up to the date of termination, pretty much always still need to be paid. Obviously, there's certain circumstances where some of those things might actually be linked to the reasons why they've been dismissed. If they've been falsely accruing business expenses, well, the ones that are dubious, you don't need to pay. However, the ones that are genuine, certainly seen this in the past where there's been a bit of a dispute over that, do actually need to be paid. The other bit of this that a lot of employers get confused about is commission, which can be tricky, and it's, again, something that people don't always quite get right. Now, as a basic principle, if commission has been genuinely earned and would otherwise be payable at the point of termination, it will usually be payable. Now, this pains a lot of people for quite understandable reasons. When you've got a gross misconduct scenario, if one of employers had a bust up and, punched somebody else, punched one of your managers, well, you might actually not want to pay them their commission. It might seem a little bit not quite right. However, it can certainly be the case that those sorts of payments would still be due. Now, this is where having very well drafted terms and conditions of employment that deal with what happens about these things on termination can be important. Can't guarantee actually that we're going to completely get you out of it, because there's certain things that just need to be paid, as I say, if it has been rightly accrued at the time. But there are things that we can look at when drafting contracts of employment for you that can help in that sort of scenario to help make your rights as clear as they possibly can be. Okay, right, just to make sure you're all still with me, I'm going to have another poll now. And when it pops up on your screen shortly, there it is. So poll number 2, you can safely dismiss somebody with under 2 years service without a fair reason or process. I'll give you a little moment to think about that. So basically what the question is asking you, can you throw caution to the wind? Can you just sack somebody because you didn't like what they wore into the office on Tuesday, or the fact that, they're having smelly lunch or something and you just really don't like it? Can you just go into the desk and go, do you know what, enough's enough, off you go, no process, no real fair dismissal? Let you have a little bit of a think about that one. So we've got true, false, or not sure. And what's it going to say? False. So the vast majority of people there are saying it is false. And you would be correct. So those people who said it is correct, this is indeed a myth, or sort of mostly a myth. So the people that are saying it's true are, there is an argument to say that actually that is correct. Technically speaking, we'll just wait for the slides to catch up, but I'm sure they'll be with us shortly. So technically speaking, the law when it comes to process and reasons for dismissal are almost exactly the same for someone with 2 months service as it is for 2 years service. You do need a fair reason. You do need to follow a fair process, and those things should be in place when you are terminating somebody. That said, as we all know, what does change is that once somebody has, what does change obviously is the risk and their ability to be able to actually bring a claim against you. So employees without 2 years continuous service are unable to bring a basic unfair dismissal claim, which really means that the risks of a successful claim are significantly less, it's much lower. As a result of that, there can be circumstances where an expedited process is followed that falls far short of what we'd normally expect to be seen and not in compliance with the ACAS Code of Conduct. However, what I would just say is that just because the risks of a claim are less, it doesn't technically mean that it's always a good idea. So we wouldn't necessarily suggest that you do go into the office one day and just fire somebody at will just because you fancy it, while you possibly could. Now, in the absence of a fair reason or process behind the dismissal, an employee may start to ask questions for that dismissal, particularly if they hold any applicable protected characteristics and those sorts of things. So really what we would recommend is that employers follow some form of process, even if it is a very expedited one, to demonstrate why it is that you are terminating this person, preferably something that fits into a fair reason, because obviously it will just help you help you with your defence if a claim is brought in due course. Okay, so it's a bit of a halfway house of that one. Right, next slide then. This is fairly similar, but with a slightly different stance. So number 8, you are safe from claims relating to dismissal as long as you follow a fair procedure. Now, so we've just said, obviously, you should really follow a fair procedure. That's a very sensible plan, even if it's some, an abridged version. Are you safe if you do that? Well, this, unfortunately, again, is another myth. Now, the sad truth is that following a fair procedure for dismissal, while of course it's very sensible and generally speaking required in most circumstances, gives absolutely no guarantee that you're not going to end up with an employment tribunal claim being brought against you. If that employee has more than 2 years service, the option of instigating an unfair dismissal claim will still be available despite your best efforts. You can do everything right. You can follow a wonderful process and you can think, no, I did that, I did a good job there. Still, you might end up with a claim. Unfortunately, there's no guarantee that you're not going to get one. Now, as said before, this doesn't mean that you should absolutely just think, oh, what's the point? I'm just going to sack everybody, and if I'm going to get claims anyway, I might as well. Well, obviously, hopefully you won't get a claim if you do follow a fair process and have a decent reason. But if, worst case, you do end up with a claim, there are still some clear advantages of having followed that process. Firstly, it gives you a good basis for your defence, which is going to be really, really important in making sure that you don't end up with a successful claim on your hands. Secondly, can really help you with negotiation. So if you're looking to settle the claim for commercial reasons, for example, or actually because it's not commercial reasons because you have actually done something wrong, or if you are looking perhaps to convince the employee that they shouldn't continue with their claim because quite clearly the legal tests were met and you did do everything right, that's again another reason why it's very useful to follow that process, and you can use that to back up your stance. It can also reduce the claim value. Potentially, you can have a good argument against that. But actually, importantly, and this is the last one on the slide there, is that it can help avoid that 25% ACAS uplift from not following the ACAS code properly. So as I say, it is important. We would strongly recommend you follow some form of process, even if you end up with a claim, because it'll be really helpful. Right, last one then on dismissals, and this is again quite another commonly misunderstood one, which I've just obviously given the answer away there before even starting. So number 9, when a fixed contract ends, it is a simple matter. There is no right to bring a claim for unfair dismissal. So what we have, and I've always said this again, is another myth. Many fixed term contracts, I mean, the clue is in the word fixed term. So fixed term contracts provide that they will terminate automatically on a set date or on the conclusion of a project. And that will happen pretty much automatically without the need for further notice to the employee. And that's what most people are sort of working on the basis of. So you've got, something's going to happen at that point, right, you're off, out you go. So as a result, many employers, understandably assume they can just let these contracts expire without the need to follow any sort of process or give any reason to the employee of actually what's happened and why they've been dismissed. The important point for everyone to remember is that whilst there may be a very good reason for that expiry, effectively the non-renewal of a fixed term contract does amount to a dismissal. It does count as a dismissal. So you are terminating somebody's employment at that point. So if that person happens to have been with you for more than 2 years service, or if the reason for the non-renewal is for some sort of discriminatory reasons, could be pinned as a discriminatory reason, the employee may be able to bring a claim if there isn't a fair reason for that dismissal and a fair process wasn't followed. So, when you're looking at this sort of scenario, you're really going to give a little bit of thought as to why you're not renewing it. What's the reason? If it's a very clear open and shut end of a project, or some, maternity leave covers returned, there could be redundancy situations, those sorts of things, but you need to put that label on it and you need to follow the correct process. Right, moving away from dismissals now, although still with some sort of dismissals, but actually looking at from the aspect of sickness and disabilities. So my first scenario in this is the statement of you can't dismiss a disabled employee. This one is another myth. You can, but you can be, it's understandable why some people think you might. So we've obviously got the Equality Act that is governing a lot of what we can do in this scenario. And the Equality Act prohibits a number of things. So the Equality Act prohibits, so we've got direct disability discrimination, indirect disability discrimination, discrimination arising from a disability, disability harassment and victimisation in the workplace. And it also, of course, puts us under a duty to make reasonable adjustments for disabled employees and job applicants who are placed at a substantial disadvantage because of their disabilities. With all that legislation in place, it's quite understandable why this is a very commonly believed myth. It does seem like quite hard work. So, while dismissing somebody who does have a disability may carry an additional risk of claims, there is really no express rule of law to prevent you from doing it if necessary. You're not expected to keep a disabled employee's job open indefinitely if they are unable to perform it. It could be because they're on long-term sickness absence, they have frequent short-term sickness absences or unable to perform the job to various required standards. The crucial thing with this is, with most things, and oh goodness, if I say procedure one more time in this, but you do need to follow a fair procedure. So you need to really think about it. You're going to need to look at things like consulting with the employer and or their, seeking medical evidence. You're going to need to establish the condition, the prognosis, what potential adjustments you could make, what ways you could facilitate them to come back to work. All of those sorts of things are going to form part of this particular process. But at the end of that, it could well be that you can reach a point where you can fairly dismiss. Now, as I say, it does come with a slight risk of litigation, as it really is the case with dealing with any protected characteristic. So you just need to make sure that as you go through this process, you need to keep a track on it, making sure that your dismissal is fair and not being discriminatory. And hopefully you would subsequently avoid a successful tribunal claim being brought against you. One thing I would say, I suppose typical lawyer, but I would say, you know, this is a type of scenario where it's very sensible to take advice. This can be tricky, and it can get quite tricky quite quickly, and wrong steps to be taken very, you know, innocently. So I would certainly say this is an area where, if you're thinking about doing this, do come and speak to somebody. Next one. Right, you have to wait until an employee has exhausted their sick pay before you start to tackle their absences. This is another myth. There are no hard and fast rules on how long an employee has to be off sick before you can consider dismissal on capability grounds. It will depend very much on the impact of the employee's continued absence. You know, things such as that, you know, what is the impact on the business? When are they likely to be able to return? You know, if you've got an absent employee who's in a very key technical role within your business, covering their absence on a temporary basis is actually really difficult. You know, you need to get someone in permanent replacement, those sorts of things. You may actually be justified in moving towards a dismissal on capability grounds a little sooner than you might with somebody else. So, you know, you're going to have to really ask yourself questions in this scenario. So, such as, well, when are they going to be able to come back? Is it in the near future? Well, if it is, well, why can't you wait for it? You're going to have to be able to be quite careful on your justification for your reasons of moving to that. But as I say, even if you have contractual sick pay still in place, it is possible. That doesn't prohibit you from starting the process. For people on long-term sick leave, just as a bit of a flag, you would want to potentially consider whether ill health early retirement might be an option for you. If you've got insurance policies, and if you've got income protection or permanent health insurance, those sorts of things in place, you should be encouraging and talking to your employee about that and seeing if they can make a claim on that policy if appropriate. You know, if you are dismissing them and preventing them from the chance to make that sort of claim, it could actually end up being very, very costly. So a bit of a big flag on that front. But yes, all things considered, it is possible. Next one then, and we have got another poll, which is going to pop up on your screen shortly. And this is quite a good one. So, if I don't like an employee's choice of companion, we're talking about, you know, if you've had a consultation meeting or a disciplinary meeting, those sorts of things. If you don't like the choice of companion, you can tell them to choose somebody else. And this is true, false, or if you don't know, then you don't know. That's fine. I think you know, many employers have been there. You know, they've invited somebody to a disciplinary hearing or a redundancy consultation or whatever it is, and then they get the news that they're dreading. The employee has picked their companion, and they are the most argumentative, opinionated, most difficult person in the office, and they're going to come and be at all your meetings with you. You know, you've had them in a meeting before. The meeting took 3 hours for something that should have taken 20 minutes. Can you tell them to choose somebody else? I think we've got our poll results, so false. So yes, if you don't like a choice of companion, you cannot ask them to choose somebody else. That is entirely correct. So, as I say, the right to accompanied, when that applies, the rule is that the employer must permit the worker to be accompanied at the relevant hearing by one companion who has been chosen by the worker from within some specified categories, and that's all set out in the legislation that's up on your screen there. Now, as you know, I think most of us probably know, choice of companion generally tends to be either your trade union official or another of the workers, sort of the employer's workers. Now, as long as the person falls within the set categories, you are not able to deny the worker their choice of companion, and that is set out in the case just on your screen, the Toll and another case against GB Oils Limited. Now, this was a case back in 2013, so people who were thinking that maybe you could actually, maybe you're thinking before that time when actually you could say, no, you're not having them, they'll be a nightmare, pick somebody else. ACAS has actually updated everything since the decision in Toll. It was quite a important case, and basically it is equally pushing a little bit back on the employer, saying, look, really, as a matter of good practice, they do need to bear in mind the practicalities of the arrangement, you know, choose someone who's suitable, willing and able to be on site, all of those sorts of things. However, in light of the decision in Toll, a companion's suitability, willingness or availability on site cannot be used as grounds for actually outright rejecting a request to be accompanied. There are some specific provisions about consequences, non-availability, chosen companion, those sorts of things, but I'm not going to go into those in any great detail today. The thing that I would say is that while you're not able to say absolutely not, you're not having that person, say unless they can't they can't attend for a number of weeks or those sorts of things. There are those sort of issues. There can be ways around it slightly. You can have a conversation with the employee, practical, sensible sort of stuff, saying, look, you know, this person can be known to be a little bit argumentative, and actually they might not help you because you may well not be able to hear yourself think for all the stuff. Have a conversation with the individual that's been chosen to be a companion as well, and say, you know, talk to them about it. Is it really the best scenario? If you really wanted to, and you were like, do you know what, I'm just going to take a risk on this, I'm going to say no. I'm going to flatly refuse to hold the meeting. I'm not going to let them have that person. Well, you could. I mean, the risk is that you may well end up with a claim because, as I say, it is a statutory right, and there are various risks. That said, the risks, when you look at the actual compensation here, is actually fairly minimal for the most part. So the award that can be made is up to 2 weeks' pay. And then the statutory maximum on a week's pay will apply during that. Now, interestingly, in the toll case, the EAT actually suggested that an employee's remedy for the breach of their right to choose their companion in cases where they haven't suffered any loss or detriment should actually be limited to an award of nominal compensation. And they actually suggested the grand sum of £2 as a possible amount. So you may well actually think, oh, for the sake of £2, I might actually take the risk. That has actually subsequently been followed in other case law, so it would appear to be reasonably good law. I mean, it's not guaranteed. Don't take my word for it. You know, I'm just going to get £2 and that's going to be it. But it is a potential. So there may well be worst case scenario. I would never recommend you do this, but if you really felt that you had no other alternative, that could be something that you look to take a view on. That said, big warning. Whilst that may well be the case, you may be one of the lucky ones. You might just only have £2 to pay. Don't forget that the ACAS code, whilst it reflects a decision in toll, basically does mean that there is a risk that you will be deemed to be not complying with the ACAS code of conduct, and then you've got that little 25% uplift if you unreasonably follow to do so. So there is that risk as well. Don't forget that. So on balance, you're going to need to look at this quite carefully. Definitely come and take advice if you're even thinking about doing it. To probably tell you not to do it. But yeah, if you want to have that discussion, then we would obviously welcome it because it'd be very interesting. Right, okay, moving on then, more disciplinary matters. So you should always suspend an employee before investigating, when investigating misconduct. This is another myth. Very much a fact-driven situation here. For certain types of misconduct, it will be exceptionally strange and almost certainly questioned by the tribunal if you don't suspend. However, it shouldn't be given for any misconduct, regardless of the type. Remember, suspension should not be seen as a sanction. It shouldn't be a penalty or a punishment. It should only really be used when it's actually necessary. So, for example, if you need to protect the business, or you need to protect your workforce, or prevent prejudice to the investigation that's taking place. It shouldn't be a knee-jerk reaction and not applied in all circumstances by any stretch of the imagination. Next one, okay. Employees should always be given a verbal warning for misconduct before moving on to written warnings. Now, this is another myth, and there's lots of different practices that different businesses have in this, but what we would say is that generally speaking, formal verbal warnings should always be used with a certain level of caution. Really don't like seeing these as a necessary step in disciplinary policies if at all we can avoid it, because it can give you various sorts of issues and actually prevent you from progressing towards a dismissal if that's actually your goal. You know, day-to-day management, quiet words, as ACAS refer to them, those sorts of things absolutely should be taking place, and you should be doing that with your employees and making sure that that kind of, you know, day-to-day picking up on any small, minor, very trivial issues that happen. If it's going above that, though, if it's something that actually should be coming out as a formal warning, then you need to treat it as such. The problem that you've got with verbal warnings comes from various different things. As I say, if you're giving a verbal warning that is anything other than having a quiet word, you really need to think about what it is. And I sort of said the status of the verbal warning on the slide there and referring to that. You know, if you're giving a genuine verbal warning, just picking somebody up on something, it's basically saying that, you know, it's minimal procedure, no right of appeal, those sorts of things. It shouldn't be written down, it shouldn't form part of their disciplinary record, certainly shouldn't be referred to in any subsequent disciplinary proceedings. That said, if you happen to be one of the employers whose policy or practice is to record your verbal warnings in writing, it's obviously a little bit, but many do. If you happen to keep a copy on the employee's file, if you're taking that account of that verbal warning into any subsequent disciplinary proceedings, the risk is that it will arguably amount to a formal warning for the purposes of the Employee Relations Act and the ACAS Code. So you will need to tread really quite carefully. You're going to need to start thinking about things like, do they need to be accompanied at the hearing? Those sorts of things. So what I would say is that whilst obviously general, picking people up on issues as they go along is absolutely fine, if you have got yourself into a cycle of having those sort of slightly more formalised verbal warnings, or indeed if your managers are actually in a cycle of not ever really getting to the stage of issuing proper formal warnings that you can then rely on later, you really need to have a think about whether that's what you want as a business and whether you need to do anything to change about it. So if you'd like any advice on that, again, do take some legal advice on it. See if you can change your policies, because the problem is what you don't want to end up is just going round and round in circles, never actually making it past the verbal warning stage and actually having something concrete on place that you can safely rely on to be able to move to a dismissal in due course if needed. Okay, moving swiftly on because I'm conscious of time. Family matters is the next topic. And a bit of an interesting one here. So asking about family plans at a job interview is illegal or unlawful. Right. This one, I mean, it'd been interesting to have done a poll on this, but this one is actually, weirdly, a myth, but it's a terrible idea. Please don't do it. There is no formal prohibition on actually sitting down with somebody in an interview and going, so what are your plans for starting a family? But obviously, if you then go away from that and then don't employ that person who's just disclosed that thinking about having a baby in the next couple of years, and you hire a man instead, you can have all sorts of headaches, and you would rightly expect a claim on your doorstep. So yes, not technically illegal, a little bit of a joke one in there, but yeah, it is a terrible idea, wouldn't recommend. Okay, next we have another poll talking about temperatures in the office. So the next poll that's going to pop up on your screen says, so employees can refuse to work when your office reaches which maximum temperature? You've got 4 options there, so 25 degrees Celsius, 30 degrees Celsius, 32 degrees Celsius, or there is no set maximum temperature. This is one of those things, I think, even when I think back to when I first started working in an office, it was always like, oh, well, if it gets too hot, you can't work. Well, what does this all mean? I'll give you a couple of minutes to have a think about that one, a couple of moments, should I say. And we'll see what the consensus is. There we go. There is no set maximum temperature, and that is correct. So the rumour of if your office is too hot or too cold, your employees don't have to work is pretty much a myth. I'd say it's a partial myth. So at the moment, there is no current law in the UK which states that any given temperature is actually too hot or too cold to work. There's no golden time when employees go, oh, hang on a minute, no, my watch says it's 30 degrees, I'm off. What we do have is a number of sort of helpful-ish things that guide us on what we should do if it's getting a bit warm and stuffy in the office. So the Workplace Health, Safety and Welfare Regulations 1992 requires employers to ensure that temperatures in all workplaces inside buildings are reasonable. Okay, not massively helpful. We've then got the HSE approved code of practice, or one of the HSE approved codes of practice, which sets a limit, and they actually do try and do something about setting a particular number on it. So they are setting a limit of a minimum workplace temperature of 16 degrees or 13 degrees if the work being carried out involves sort of severe physical efforts, people getting hot anyway by the fact they're moving around and lifting things. They, again, haven't put any limit on the maximum temperature. HSE recommends that temperature in all workplaces inside buildings, again, should be at a comfortable level. Now, the problem with all of these things, when we talk about reasonable temperatures, comfortable levels, is that what is actually deemed as comfortable comes down to, well, a number of factors. It will also depend on the particular type of individual, the type of workplace. You know, different people have different, if some people feel the cold, some people don't. Some people may have health issues and all those sorts of things that actually get worse when they get too hot. So the issues that unions and other organisations have been trying to really push through and campaigning quite heavily to get fixed temperatures agreed have faced is that actually it is very subjective. It can vary massively on a number of different factors, so it really hasn't been felt possible to put a fixed temperature in place. You're probably aware you don't legally have to provide things like air conditioning. Staff are still required to dress appropriately. You know, if that's a uniform that they have to wear, they should technically still be wearing that, even if it is a bit hot, unless they've been formally informed otherwise. But the point for employers is that you do have to think about this sensibly. You do have to bear in mind, obviously, you do have a duty of care to the health and safety of your staff. You know, you don't want people fainting in the office because it's too hot. Have a think about it. You do need to provide fresh air as one of the actual requirements. It is quite clear. You know, there are adjustments, measures that can be put in place. If you've got your employees coming to you, speaking to their managers, which is what they're recommended to do, see what can be done, and just say, keep it looking at things about what's reasonable, what's comfortable. That's what you need to work on. Right, okay, moving on to our final topic. So I'm going to be looking at a couple of points about resignations before we move on to questions. So the first one about resignations, and I quite like both of these actually, they're quite interesting. So I've got two statements here. So either a resignation is not valid until accepted by the employer, and the other one that's very similar, I can refuse to accept a notice of termination. And I hear this a lot, but it is a common misconception. So notice, and particularly, so a very common misconception, notice, particularly notice of resignation, is not valid until it has been either accepted or that a party can refuse to accept another party's notice of termination. Really not the case for the vast majority of circumstances. The position at common law is actually that a notice, once it's been validly given, is effective and cannot be refused. So, you know, if you've got someone, you go, no, not having it, go away, carry on working. Well, actually, that's not necessarily going to work. There are a couple of exceptions. I don't really have time to go into those in any great detail. I've put some cases, or in particular case, the Gaze case, up on the slides there for you, and that's talking about things such as where an employer gives notice in repudiatory breach of contract. It's not going to be deemed accepted and deemed effective until it's accepted by the innocent party. And we see that, you know, coming through various case law. Equally, if the employee is giving a short notice in breach of contract, so they're entitled to 6 months notice, they say, actually, I'm going tomorrow. Well, again, the employer may choose not to accept the actual principles under which they are serving their notice. So there are a couple of little exceptions there, but as a general rule, if someone gives you their notice, as long as it's actually validly communicated and ticks all the boxes, then it's probably likely to be need to be accepted, well, not need to be accepted, because it will be in place. Right, the last one before we move on to questions is when an employee has resigned, it is final and they cannot change their mind. Now, this one is, again, it's mostly true, to be honest. Once a valid notice has been given, it cannot be withdrawn unilaterally, whether by the employee or the employer. However, there are a couple of circumstances where an employee may be allowed to change their minds, albeit very limited ones. Now, the ones I think most people have probably heard of is where the employee resigns in the heat of the moment. So yeah, this is a sort of scenario, you know, there's a great big argument going on in the office, boss is shouting, employee shouting, employee's like, right, I quit, I'm off. Now, if that happens, what case law has established is that actually it is good industrial relations practice to give that employee the reasonable opportunity to retract their resignation once they've had the opportunity to calm down. And that is the case with the Martin and Yeoman case that I've got on the slide there. Now, in these situations, if you have had that sort of scenario that's come up, it might actually be that you really don't want them back. You don't want to say, well, no, you can't reconsider. No, you can't take it back. You quit. You need to go. You need to leave. Get out. If you do ever end up in this scenario, which certainly does happen, I've seen it a few times, I would really recommend that you take advice. Again, it's pretty sensible before making a firm decision. It could be that you actually, unfortunately, do need to get them back in. If they have been shouting and effing and blinding and all the rest of it, well, it could well be that you actually get to discipline them and then get to terminate them anyway. But as I say, you may have to give some consideration to that. The other thing that I've just mentioned very briefly is unreliable notice. Now, the Court of Appeal has identified some special circumstances that might mean that an otherwise clear and unambiguous resignation, which is effectively what it needs to be, cannot be relied upon by an employer. One of those points, and this is the Southern Franks case that I've got on the slide there, one of them is the heat of the moment that I've just mentioned. The other one is when you've got a very immature employee, and that can be a reason why actually you need to take it back, because it's actually going to be unreliable because of that. And the other one is where the employee has been jostled into a decision by the employer. So, you've been really goading them into it. Well, do you want to go? Just go. Oh, fine. It's that sort of scenario. So in those kind of situations, it can be something that you would need to would need to accept the fact that they can change their mind. Right. Whistle stop tour there of a number of different things that I hope you found interesting. And what we will do now is move on to some questions. So I'm just going to invite Jackie and Ian to join me on screen. There they are. Hello. So for those of you not familiar, obviously we've got Ian Machray here and Jackie Denham, two of my colleagues in the employment team. So hopefully, I think that Jackie may have been going through any questions that we've had coming in.
I have been through them, Katie. Thank you very much. There's not a huge number there, so if anybody has got any additional ones, feel free to ping them across and we'll try to answer them in the next 10 minutes too. I guess the first one is, I guess following on from one of the scenarios you talked about, Katie, was, okay, well, if you can't rely on the fact that a contract's not been signed and has just been accepted by custom and practice or by someone continuing to work, what are you meant to do then if an employer refuses to sign their contract? Ian, do you want to take it? What are you going to do?
What am I going to do? So this is a scenario where so you've issued the contract at the start and then they're refusing to sign it sort of a few weeks in. I think it depends a little bit in terms of how clear it is in terms of ongoing employment. Obviously, you've got the whip hand sort of in early stages of employment. They don't have the length of service for an unfair dismissal claim. You could just get to the point where you're saying you need to sign your contract, or unfortunately, we're giving notice to terminate probably in your probationary period. That's your nuclear option, or I guess you can threaten that to get them to sign it. But yeah, I think it's going to depend upon how important it is for you to ensure you can rely upon that contract. So if you've got someone in a very senior role, access to clients, confidential information, yeah, you're definitely going to want to make sure that it's all signed off. So yeah, I think it's better to resolve it early doors would be the advice.
Perfect. I've got one just come in. Can you give, wow, so many questions firing and they're all like moving up my screen. Hang on a second. Can you give a self-employed contractor a trial period without obviously suggesting it's a probationary period or otherwise alluding to a different employment status?
So I'll give you a break, Katie. So yeah, well, you could. I think you've just got to bear it in mind. It will go into the mix as to whether you've got a genuine self-employed relationship or not. So anything that looks like a probationary period is much more common in an employment context. Most consultancy arrangements are normally more ad hoc or project-based in nature, in which case a probationary period would be slightly unusual. I think you could have something whereby there is a sort of a trial period, but you just need to make sure that all your other factors are pointing towards self-employment. If you had a variety of things that were looking a bit employment-like, then I think you could get into issues. But if everything else was, it's very much arm's length, business-to-business relationship, then, and if that's your only sort of factor pointing towards a potential employment relationship, providing you term it in the right way, I don't think it's fatal. You have to say if you disagree, you two.
We always would. Just in terms of references, can we clarify, are we allowed, is an employer allowed to refuse to give a reference, and are they actually allowed to give a negative reference?
I'll take it.
Do it, Katie.
So, sorry, say the question again. So, are we allowed to give a negative reference?
Are you allowed to give a negative reference, and can we refuse to give a reference completely?
Okay. Well, again, it can sometimes depend on the circumstances. There's sort of fairly the rules that we look at when we're talking about references is what you should be trying to achieve with a reference if you are choosing to give one, is it needs to be sort of like fair, truthful, balanced. So if you're looking at giving a negative reference, it can potentially cause you some difficulties. As I say, that piece about it being balanced, there's nothing to stop you from giving one, apart from the fact the employer might not be better pleased about it. It can cause you some problems from that perspective, but generally speaking, it depends on the connotations of that refusal. If you're going to say no, it would depend really on, yeah, the impact that might have on me. So I'm not answering this question very well at all.
No, I think it's spot on. I think you could do it. Most people won't bother. They'll either not give one at all, because the risk is in giving a negative reference that the employee is going to try and come back and argue with you about it. So you'd have to have good business reasons to want to have that argument, I suspect.
So I've got a particular scenario here. What do you do if an employee who's clearly unable to perform due to their health constantly tells you that they are able to perform, but actually even occupational health says that they're not fit to work? Occupational health says they are fit to work. The individual says that they're able to perform, but obviously as a company you've decided that they're not able to perform in that role, and they could potentially be covered by disability legislation. What do you do?
Well, I think you're into sort of normal performance management territory. You've got an employee who's saying they're fit to work. You've got medical evidence that says they're fit to work. Assuming there's no reason to doubt that medical evidence to such extent you need to go get something else, you'd be entitled to rely upon that in working out if there's any reasonable adjustments. And then if there are none, or you've already done them all, then you're into normal performance management territory. So setting clear goals, manage them against them, series of warnings, and ultimately through to dismissal. Yeah, I don't know if either of you have anything to add on that.
No, I would agree. Unless there's any suggestion in that occupational health report that any adjustments at all are necessary, I assume you can rely on the fact that there aren't any adjustments that are required because they're able to perform their role adequately. So if you therefore consider they're not performing, there doesn't seem to be any adjustments you would need to make to potentially be wary of it, and just follow the process through and make sure you're consulting a lot with the individual before making a final decision.
Yeah, absolutely. Yeah, you're not expected to be a medical expert, so if you've got evidence in that says there's not an issue, you have to act on the basis of the information you've got as an employer.
If an employee has repeatedly said, so they're off on long-term sick, and an individual repeatedly says, I'm going to resign, and obviously you'd quite like them to, but they don't ultimately submit their resignation, at which point can you try and enforce that issue, I guess? I mean, the question is, at which point can you just take their resignation? But obviously the answer is you can't take the resignation until they resign. Is there a point at which you can actually force them to decide if they're going or not?
It goes back to what Katie was saying. So you can't accept that resignation until you've got a valid one. So if at any point they say something where it is clear that they are intending to leave, so you've got that certainty, it's not in the heat of the moment, everything else, then in theory you could rely upon it then. But obviously if you've got a catalogue of fake resignations, I guess, or whatever you want to call them, then you need to be careful to make sure you've got one that you can rely upon. You can obviously ask them to confirm it, and deal with it that way. It's quite difficult to dismiss someone because you think they're going to resign. So that's if you were looking at that scenario, I've got an employee and I'm not sure how long they're going to be here and I want to bite the bullet. That's quite tricky. I think you'd either be looking at, is that wish to leave manifesting itself in other ways, i.e. their performance issues, and deal with it that way. I'm obviously assuming they've got 2 years service. You might be able to get to a stage where there's some other substantial reason you need to plan for the business, you need continuity, and therefore, it would be a high risk dismissal, I think.
I agree. I'm going to stop it there, Katie, because we've got 2 minutes.
We are coming to the end of our time for today, so thank you very much for those questions. If there obviously are any more that Jackie's got on the screen, she's nodding. We will do our very best to cut. No, she's shaking her head. We will do our best to come back to anybody else. I do hope that you found today interesting and helpful. If you knew all the answers, well, brilliant. That's wonderful. If there aren't any things that surprised you, then well, all the better. Hopefully, you've picked up a few extra points today. If there is anything that you didn't get a chance to ask during the session, please do get in touch with us. Our details should hopefully appear. We do have a couple of events coming up over the next few months. If you subscribe to our e-bulletin for news and updates, you'll get those notified to you, or if you particularly like to hear about what we've got going on, again, get in touch with us. We can either sign you up or we can let you know in due course, because it'd be lovely to see some of you. Hopefully some of these events are now coming to be in person, so it'd be great to actually see you face to face. I can't see any of you now, so that would be lovely. Just as a quick flag, actually, the most soon coming up one that we've got, if any of you are HR professionals or work in a similar capacity, we do have our first ever HR forum coming up on the 6th of October. At this, you can expect to sort of share discussions and make connections with hopefully like-minded professionals over a coffee and pastry in central Reading. It'd be lovely to see you. We'll obviously be there as well, so please do sign up if you'd like to come along to that. That's it. As I mentioned at the beginning, we'd absolutely love it if you'd like to fill in the feedback form. It's going to pop up on your screen once the seminar closes in just a moment. As I say, there is that incentive to be entered into the prize draw for the £50 John Lewis voucher, if that helps you, compel you to sign to give us the feedback. So this is a different format to a lot of the webinars that we've done before, so we do hope you've enjoyed it. We'd love to hear what you thought. Well, and that's it. I think that's enough from me and Jackie and joining me as well today. And we hope to see you at another event soon.
Thank you.
Thanks, everyone.
Bye.
Bye-bye.